I'm Drew Stevenson, and this is a lecture about the case Rice versus Santa Fe Elevator, a U.S. Supreme Court case from 1947 about federal preemption of state laws and whether there's a presumption against preemption. Now, for my students, this is a lead case in my Statutory Interpretation and Regulation class, or casebook, and it also comes up a lot in our preemption section of administrative law. So it appears in some administrative law casebooks and so forth. It's an older case, but it kind of nicely illustrates some of the issues with preemption. And remember, there's a clause of the Constitution that we call the Supremacy Clause that says whenever there's a conflict between a state law and a federal law, the federal law wins. And the question is, when is there a conflict? To what extent do they conflict? When can we harmonize the statutes and so on? So let's see what happens in this case. So our statute in question here is the Federal Warehouse Act. This was a New Deal era statute, like from the Depression era or 1930s and 40s. And what it did is it authorized the Secretary of Agriculture to impose various regulations on grain warehouses and silos. And the issue here is whether this statute preempts Illinois state laws that also impose legal requirements on grain warehouses. Now, Rice, our party here, was a farmer, and he sued Santa Fe Elevator Corp. And we don't mean elevators like you might take in a building that carry people. We mean elevators like the one in the picture here that are for processing and storing grain. And he said that the granary he was using had committed numerous violations of Illinois state laws that governed granaries and warehouses: excessive fees, price discrimination, operating without a license, mixing grains of different grades, and so forth. And so pursuant to state law, Rice brought these complaints before the Illinois Commerce Commission. And then Santa Fe Elevator Corp moved to dismiss the complaint from the commission on the grounds that there was a federal statute, the Warehouse Act, that superseded and therefore preempted these Illinois laws. And part of what's tricky about this case, or interesting, is that the act was amended at one point specifically on this issue of preemption. So here's what it originally said, and I'm going to read the quote to you. Quote, "Nothing in this act shall be construed to conflict with or to authorize any conflict with or in any way impair or limit the effect or operation of the laws of any state relating to warehouses or warehousemen." And so I like that for purposes of illustration of Congress trying to express clearly an intent not to preempt. So it's almost the opposite of an express preemption clause. It's like an express anti-preemption clause. It's saying that the statute should be interpreted in a way that leaves state law intact and in effect. But Congress later on amended this statute before this case came up and added this: the power, jurisdiction, and authority conferred upon the Secretary of Agriculture under this act shall be exclusive with respect to all persons securing a license hereunder. And so, in other words, they're saying that once you get a federal kind of granaries license or grain warehouse license, that you've submitted to the jurisdiction of the Department of Agriculture, and that nothing should infringe on the Secretary of Agriculture's authority. So that's a somewhat stronger, that sounds like preemption. And hence we have this issue for the Supreme Court to resolve. The court here, and as you can see, it's an early Justice Douglas opinion, concluded that the federal statute did preempt state law on what we call obstacle preemption grounds. And so this, if you remember, we have three types of preemption. We have direct kind of conflict of implied preemption. We have direct conflict preemption where obeying the federal statute puts you in conflict or violation of the state statute. We have field preemption, and then we have what we call obstacle preemption, where one statute, the application of one statute or applying state law would sort of interfere or create tension or friction, I guess, with enforcement of federal law or the exercise of certain federal authority. And so the court sees this as an implied preemption case. The federal statute itself doesn't have an express preemption clause, but the amendment suggests that that was Congress's intent was to preempt when there was a problem or some sort of conflict in the application or operation of the law. Here's a quote I pulled out for you for people who like to highlight things in their cases. We start with the assumption that the historic police powers of the states were not to be superseded by the federal act unless that was a clear and manifest purpose of Congress. And so that's a nice way of putting that they start with a presumption against preemption. So make sure you understand that even though we have a supremacy clause, that we have federal preemption of state laws, and it can be express or implied, that we start with a presumption that there is no preemption, and then it's the burden of the party who's asserting there is kind of show actually to overcome that presumption and show that in fact Congress did intend this. So the majority infers here, that's what we have to do when we have implied preemption, that Congress intended to preempt. And they kind of did this from three angles. First, they looked at the very fact that Congress had amended the act as significant. Basically, the original act wasn't satisfactory, there was something that necessitated a change. And they infer from the fact that the original act was very clear that there was no preemption, and then Congress felt the need to change it, that the original act was causing problems and the lack of preemption. And the exclusive verbiage, it's pretty strong, right? In that amended quote that I showed earlier, and other provisions of the amendments. And then there's also a lot of statements in the legislative history about making the federal act independent of state laws. In other words, the bill sponsors and people promoting the bill in Congress were saying that they were actually worried about state laws interfering with the job of the Secretary of Agriculture or the Department of Agriculture in enforcing this statute. Here's another quote that I pulled out for you from the opinion that I thought was helpful or illuminating. The test, therefore, is whether the matter on which the state asserts the right to act is in any way regulated by the federal act. If it is, the federal scheme prevails, though it is a more modest, less pervasive regulatory plan than that of the state. And so this is an important point to remember about preemption doctrine generally, is that a lot of times you have an individual state that would like to go further or have a stricter or more severe statute than what the federal government adopted. This should make sense to you, right? Because a local rule would be representing the state legislature of a lot of people who live there and have more in common. And federal statutes from Congress are the result of a national compromise, right? People from all over the country have to agree, who have kind of skin in the game, pulling in different directions. And so it's not uncommon that a federal law is more moderate than what the state would do if they were left to their own devices. But this can be confusing in federal preemption, because the question is, why can't the state go above and beyond or require above and beyond what the federal government is doing? And that was the issue in this case, is that basically Illinois had somewhat stricter rules or more detailed rules than the Federal Warehouse Act did. So the court ends up, the majority reversed or held that the federal law preempted state regulation, but only for certain alleged violations in the complaint, those that overlapped with federal law. And so they're applying preemption to some of the claims in the case, but not others, because they're saying some of the claims are actually about things that the federal law doesn't address at all. And so those can go forward. So for alleged violations that did not seem to overlap at all with federal statutory requirements, the court remanded it to the lower court to see if there was any conflict remaining in practice. For example, something that would interfere with the enforcement of those other provisions. Now, we have a dissenting opinion from Justice Frankfurter pictured here, and he argued that the majority had basically nullified a huge body of state regulatory law, despite there being no, he thought, no actual conflict between the federal law and the state law. In other words, he notes that in most of the time, warehouse owners could, in theory, comply with both state and federal laws because the federal law required a little less. So if you were complying with Illinois law, then you would necessarily probably be complying with federal law as well. And the reason it's worth talking about his dissenting opinion is this is a recurring concern with preemption. And the reason we have a presumption against preemption is that it basically interferes with states' rights. It nullifies the ability of a state to have some local rules or self-governance on issues. And sometimes deciding one case, for example, that not all of Mr. Rice's complaints can go forward before the Illinois Commerce Commission. That seems like a pretty isolated incident, but the decision is going to have implications for a lot of other cases, and therefore it has a lot of ripple effects for other state law. And that's Justice Frankfurter's concern here. And that concludes our discussion about Rice versus Santa Fe Elevator Corp.